Good morning, everyone. I would like to call to order this meeting of the House of Commons Standing Committee on Foreign Affairs and International Development. We are here meeting this morning on Bill S-240, an act to amend the Criminal Code and the Immigration and Refugee Protection Act, trafficking in human organs. This morning we have the sponsor in the House of this bill, MP Garnet Jennis, who's going to be providing us some testimony, and then we'll be hearing some questions from members. And I think given that there's a lot of interest in this bill in the room, why don't we let MP Jennis get right on with his testimony, and we can open it up to the floor. Please proceed.
Well, thank you, Mr. Chair. Thank you, colleagues. At the outset, I'd like to start by recognizing the work of Senator Atulajan on this bill, as well as others who have proposed similar bills. Mr. Yashnevsky, who's here, who got this ball rolling 10 years ago, as well as Erwin Kotler, who for all of his work and support throughout this process. Now, this bill proposes to make it a criminal offense for a Canadian to go abroad to receive an organ without proper consent. And it creates a mechanism by which someone can be deemed inadmissible to Canada if they have been involved in organ harvesting. This touches on a number of different kinds of situations. It seeks to respond to the situation in China, where the taking of vital organs from live and often awake political prisoners is state policy. It also responds to situations where organs are taken through coercion and exploitation beyond the reach of even well-meaning local authorities. Now, in the 10 minutes I have, I don't see it necessary to repeat in detail all aspects of this issue that have already been part of the parliamentary record, that organ harvesting is a problem, that Parliament has a legitimate right and indeed moral obligation to respond to it, and that the application of extraterritorial jurisdiction in this case is appropriate. These are all points that have been well laid out already in the context of the parliamentary debate, but I'd obviously be happy to revisit them during the question period. I wanted to, during this time I have, make a few particular points about the impact and timing of this legislation. Now, first on the issue of the impact, there has been some debate in the House about whether certain provisions of this bill are necessary and whether certain provisions of the bill are onerous. One member argued that the inadmissibility provision of the legislation might not be necessary because those involved in organ harvesting could be deemed inadmissible on other grounds. Another member wondered if the criminal law aspects could be inferred into other statutes. Some members said that there are no known cases of this in Canada. And one member argued that prosecutions under this legislation could be onerous because they would involve the requirement that prosecutors gather evidence in other jurisdictions. Now, I disagree with many of these arguments. I argued in response that extraterritorial prosecutions are easier in this case because the recipient brings back some physical evidence with them and there's aftercare involved. I pointed out that while any organ harvesting that took place in Canada would already be illegal, this legislation creates a new mechanism by which that crime could be prosecuted if it took place in another country. So the presence or absence of documented cases of organ harvesting here in Canada is really beside the point. I do not believe that any provision of this legislation is redundant or unnecessary. The extraterritoriality provisions are key, but there are other aspects of the criminal law provisions that are substantive and new and important. But I would just say as well, suppose that I'm wrong. Suppose that the bill is in fact challenging to administer in points and it's redundant in its impact. If that is the case, then it may not do that much good, but it also won't do any harm. Note that prosecutions can only proceed under this legislation if authorized by the Attorney General. So if a prosecution is too onerous in a particular case, there simply isn't a need to authorize it in that particular case. The requirement for authorization is a strong check to ensure that these powers are not executed in an unreasonable way or in a way that runs contrary to the public interest. And if the immigration provisions are redundant, which I don't think they are, but if they are, so what? Who's made worse off by the extra emphasis around inadmissibility? One thing that nobody will deny about the passage of this bill is that it would send a strong message about Parliament's and Canada's commitment to fighting forced organ harvesting. So my point, colleagues, would be that at worst, this is a bill that its most extreme critics would say has low impact. I don't agree with those critics, but even if they're right, we lose nothing by passing this legislation. At worst, it's a symbolic positive impact, but at best, it will save the lives of some of the most vulnerable women, men, and children by cutting off the demand for harvested organs. If we can get other countries to follow suit on this initiative, then this will have orders of magnitude more impact on the lives of some of the world's most disadvantaged people. So whether you believe that the impact of passing this bill will be large or small, I hope you will support its swift passage. Now, on the issue of timing, members know that we are in an election year. This bill has been working its way through the process for the majority of this parliamentary session. Getting a substantive private member's bill across the finish line is not a quick or an easy thing to do, and that explains why multiple great bills on this topic over the last 10 years did not make it all the way through. If we don't get this done, then how much longer will victims have to wait? 4 more years? 10 more years? I say let's do everything we can to maximize the speed of passage of this bill so that we can look our children in the eye and tell them that we didn't just talk about good ideas, but we actually got good things done. I'm grateful to this committee and to you, Mr. Chair, for the fact that we're proceeding quickly to clause-by-clause consideration. Now, clause-by-clause will provide members with the opportunity to propose amendments. I note that this bill was studied by the Senate committee and substantially and constructively amended at that point, and it builds on detailed legal work, which includes the work of, as I mentioned, former Minister of Justice Irwin Cotler. Now, if members see a vital need to amend this bill before passing, then certainly they're in their rights to do so, and I think there would still be a shot of getting the bill passed before the next election. However, as colleagues know, if this bill is passed in present form, it will go straight to royal assent, and we will then have certainly delivered for victims and their families. If the bill is amended and it goes back to the Senate with no guarantee that the Senate will like our new revisions, I think that will complicate the process. Now, the Senate's rules are different from ours, and this close to the federal election, all that would be required is for one senator to choose to adjourn the debate in their name, and that would, I think, prevent it from proceeding. Now, under different circumstances, I probably would have proposed minor amendments myself today. But we have to take stock of the circumstance we're in, with a clock ticking hard. My sincere recommendation would be that we pass this bill in present form and therefore ensure that it moves forward before the next election. And if members want to propose amendments, I hope that they've been able to do substantial consultation with the Senate to ensure that the Senate would give quick passage to the amended version. If we got this bill, as some appear interested in doing, then we're obviously a lot worse off. But even if we marginally strengthen it, we likely will also be worse off if we are not able to get it done before the next election. So I would suggest we consider supporting this bill without amendment so that we can ensure we deliver the justice that we want for victims. In this case, we have a gaping hole in the law that allows Canadians to be complicit in a grievous violation of human rights. Our human rights architecture in this case is like a ship with a gaping hole in the side. Recognizing the urgency of the situation, I say that we need to ensure that that hole is patched, and if we subsequently need to make improvements to the patchwork, so be it. If this committee agrees to pass this bill in present form today or this week, then our chances of getting it into law before the end of this Parliament are very high. There have been 4 bills on this over 10 years, and this represents the culmination of work done by some of the best human rights minds in the world, people like Irwin Cotler, David Matas, and David Kilgore. Now, let me close with a bit of a personal note. Members know, I think, that my grandmother was a Holocaust survivor. She avoided capture. She avoided the torture of the concentration camps, despite her lack of privilege, because there were people in her community with more privilege than she had who were willing to protect her and to speak out for justice when and where possible. Now, as members of Parliament, I'm able to sit here, we all have a form of privilege, and we can choose to use that privilege to speak for ourselves, for our interests and the interests of our tribe, or we can use that privilege to speak for those who do not have a voice, for the poor and suffering of the world, like my grandmother in her time, who could not speak to a Parliament or a committee about her situation. We can be a voice for ourselves, or we can be a voice for the voiceless. Now, I think of the fact that today in the People's Republic of China, we have Uyghur Muslims being put in concentration camps, churches exploded with dynamite, and many others being killed for their organs. A couple years ago, I was in Berlin, and I spent time exploring the history and the memorials related to the Holocaust. It hit home for me seeing the crowded urban areas from which Jews were shipped by train to concentration camps. It hit home for me that people saw what was going on. I visited Sachsenhausen outside of Berlin, which is in the heart of one of Berlin's suburbs. Many of these atrocities were not well hidden. Ordinary people saw them, knew about them, and did not do enough to stop them. So why didn't they stop them? Too often, I think, people excuse themselves from doing what is necessary to stop injustice by whataboutisms. That is, they get hung up on small, minor details or irrelevant facts that distract their attention from the big picture of injustice being done against the innocent. About the horrors of the slave trade, William Wilberforce said, "You may choose to look away, but you may never again say that you did not know." So I say to committee members, you know, you have read, you have heard the stories about the contemporary horrors of human rights abuses, the horrors of organ harvesting and trafficking, and the complicity of some Canadians. We must do all we can to put a stop to this. Let's pass this bill to ensure that it becomes law as soon as possible. Let's maximize our chances of success by recognizing the legislative process as it is. And just like William Wilberforce's audience, you and all of those watching at home may choose to look away, but can never again say they did not know. Thank you very much, Mr. Chair.
Thank you very much, MP Genuis. Your commitment on this file certainly comes through in your words, and we appreciate that. I would now like to move straight into questions, and we're going to begin with MP Abeltaif, please.
Good morning, and thank you, Garnet, for sponsoring this bill, this legislation, and congratulations on your efforts. I believe this is a very, very important bill, and I hope it will pass, as I know it will make a difference for thousands of people out there. I also know that you are passionate about this bill, and you have introduced a similar legislation, Bill C-350. It is in your mind, and I know it's on your agenda. So, do you believe that your legislation, the C-350, is it complementary to S-240, or will this piece of legislation provide the protection you had in mind in Bill C-350?
Thank you for the question. So I put forward Bill C-350 in Parliament. Bill S-240 is a very similar bill Senator Tulajan put forward in the Senate. These, though slightly different in some of the details, these bills are substantively do the same thing. So no, the design was never for both of the bills to pass. It was recognizing just the difference in process, that there are certain aspects of the Senate rules and the House of Commons rules that create different opportunities to move the bills forward at different times.
Okay. Now, it seems like the main reasons of organ harvesting and trafficking, it's the lack or the lack of legal donors out there. And I'm an advocate of legal donors, of living donors, whether for tissues or for organs. Now, S-240 can really assist with the demand that out there for organs by explicitly prohibiting the organ trafficking and creating consequences for those who attempt to commit these acts. Now, do you believe in this instance that the government of Canada could make a meaningful difference by working with the provinces to address the supply side as well through National Organ Registry, as been presented before by myself and the C-223 and further from two other members?
Well, thank you very much. That's an excellent question. So when we have a case where a Canadian goes abroad to receive an organ for which there isn't consent, we recognize that is feeding and supporting a great evil, which is organs being taken from people forcibly without consent. And we need legislative mechanisms, as we're discussing today, to stop that. But I think it is reasonable, it is important to also think about the circumstances that put somebody in that desperate situation, which is as a result of a limit of supply of organs. And that is why I was pleased to support your private member's initiative on this, and thank you for your good work. And I was pleased to support as well and speak in favor of the private member's bill from our colleague Len Weber that would have improved access to Mr. Weber's bill puts on the tax forms the opportunity to indicate that you're an organ donor, and this facilitates as well that increase in supply. And I was very pleased to see Mr. Weber's bill receive strong support from all parties. So there is an interest in coming at this issue from a number of different angles. It's it's that old question of fighting crime and fighting the causes of crime, right? I don't think those things are mutually exclusive. I think we can and should do both. So hopefully by coming at it in both directions, we maximize our chances of success here.
Well, thank you. I think, yes, I think this bill can really speak to many different areas, and I think can hit many targets. And one of them, I mean, to the best interest is organ donations. And I think, I hope that the spirit of supporting the two other bills that are already in the House, from the government side, from all sides, to carry forward with this one. And I would take this opportunity to call on support for this by all sides, and to make sure that we have this opportunity to hit more than one bird by one stone and make sure that we get the result we need. So I'll leave it to you to make final comment on this area, because to me it's very, very important angle to tackle this bill through. And I think it's something that we should pay a lot of attention, and we should make it obvious to all members that this is also a very, very important element in this bill.
Yeah. Well, thank you very much for your comments and for your support. Those questions were tough but fair. So thank you for that. I thought maybe if you'll allow me just to add one issue on the inadmissibility provisions that I neglected to mention during my introductory remarks, and that is that the provisions around inadmissibility to Canada in the Immigration Act right now deal with criminality, gross criminality as grounds for inadmissibility. But in some cases, when we deal with organ harvesting, there's cases of people that are not breaking any law in the country where they are, but they're still involved in a gross violation of human rights. And that is one of the reasons why I think that those immigration provisions that are part of this legislation are very important, that somebody could be acting as they are directed, carrying out terrible human rights abuses in a country like China, where this is a matter of state policy. That person, I believe, should still be able to be considered under the inadmissibility provisions because they're involved in a gross violation of human rights. So that's an important area where this law is advancing the discussion forward. It's not, there are cases, yes, where somebody would be involved in organ harvesting who is also breaking the law in the country where they are, and that person could be considered inadmissible on both grounds. But there are certainly cases where the new provisions are necessary. So I'll just add that in addition to my comments at the beginning.
Thank you.
Thank you.
Thank you.
Thank you. Thank you very much. We are now going to move to MP Chesnevsky, please.
Thank you, Chair. And let me begin by thanking Mr. Jenis for sponsoring this legislation. And he's already mentioned the long journey that has brought us here. In fact, it's been 11 years. It was on February 5th, 2005, C500 in the 39th Parliament, that it was first introduced by myself. So I'm feeling very expectant and anxious. I believe that we can get this through our committee this week, and this could be a great example in difficult circumstances in the House of parliamentarians doing what's right on a very important file. We have support of all parties. We have the support of both chambers within our parliament. It's a rare occasion that we see this type of support, and it will be a demonstration of the legislature and legislators doing their work, and importantly, vital work. You mentioned the great work done by the two Davids, David Mattis and David Kilgore. They really shone a light in perhaps the darkest of evils of our current times. Perhaps not in the same way as you see in cases of genocide, but there was something to what you said when you referenced your grandmother. It hasn't been since World War II that we've seen human horrors on an industrial scale by a state, a government, China, on an industrial scale, taking the most vulnerable, people who've been incarcerated for their beliefs, and profiting from a systemic system put in place to literally cannibalize the bodies of those vulnerable individuals. I won't have so much a question as, so you're going to get some more tough questions, as you referenced. It won't be so much as a question, but to further provide context, why it's so important for us to do this. 10 years ago, 12 years ago, this first became an issue, and it's the confluence of a number of things that have happened globally. Medical technology. Medical technology wouldn't have allowed for these sorts of transplantations 20, 30 years ago. So it was a change in medical technology. And then this global disparity. You have people of the wealthy West, and you have, it's not just China, but destitute farmers in India falling victim to this type of trafficking. Orphans, 17-year-old orphans in Ukraine falling victim. So the most vulnerable globally are the victims of this horrific trade in human organs. And if people say that, well, that's far away, it doesn't affect us, it does. And in ways perhaps that need reminding. Soon after, I think it was the week after I introduced the legislation, February 5th of 2008, the Toronto Star had headline stories about Dr. Horror from Brampton, who had lived in a mansion, had a very good life here in Canada, and had a series of clinics in India that preyed upon the most vulnerable. Farmers who were destitute were promised significant amounts of money, didn't always receive them, weren't necessarily explained that you can only donate one kidney and not two. So I'd like to conclude my statement of support by saying this is a horrific trade. All of the trends that have led to this trade are increasing. The income disparities, the number of vulnerable, medical technology, and we should be a leader. We can be an example for other countries by passing this legislation. So I thank you, and I have a minute and a half left if you'd like to comment on any of the statements I've made. Thank you.
Thank you so much again, Mr. Yashnevsky, for your comments and your work on this. I do want to make sure that people watching this don't get the impression that just because we've been agreeing so far that this is going to be easy, right? It's February. The parliamentary session goes till June, and there's details that are part of the discussion. So the continuing engagement of people at home, the decisions we make about how to move forward are critical. So sometimes even if there's facial agreement, there's still a lot of hard work. So people shouldn't be complacent, even though they're seeing agreement. But it's good to see that agreement, and I think we have an opportunity, as you say, of parties to work together. February of 2005 was a long time ago. It was a longer time ago for me. I was in high school at that time. So hopefully my kids won't be in high school before we get this done, right? And just in the remaining time, Boris, you raised this issue of I think it's a critical one, of injustice in an interconnected world, right? In a more and more globalized, interconnected world, there are opportunities for exploitation and injustice. There are lots of great opportunities that come from interconnectedness, but there are opportunities for injustice and exploitation. And I believe that's why we need to be willing to use more extraterritorial provisions. We did this in child sex tourism when it came to light that people were going overseas and engaging in this horrific practice of child rape, essentially, that we said, in an interconnected world, we need new legal tools that respond to new forms of injustice. And that means prosecuting people for terrible things that they do overseas, even if they're not doing those things within our country. And this is an extension of that principle. And an important issue for this committee to explore in general is countering injustice in a more and more interconnected world, where people aren't just exploiting others at home, but they might be involved in exploiting others overseas. And that will require creative ways of thinking, new legal tools, and we can't just be complacent and think the tools of yesteryear have kept up with the current trends in terms of travel and technology. They haven't, and that's why we need to be adaptable as well.
Thank you very much. We shall now move to MP Ramsey.
Thank you, Mr. Chair, and thank you to the committee for having me this morning in replacement of my colleague, Madame Laverdière, who couldn't be here this morning. But I think it's clear that the NDP supports this effort and really hopes for that swift passage as well, given the timeline that we're up against, which you've highlighted well. Also, that we strongly oppose the trafficking and the abhorrent treatment of those who are manipulated and abused and exploited for their organs globally. Is of significant concern to New Democrats as well. So we do hope that this moves swiftly. You mentioned some domestic issues, right, that are a struggle. And I, like many Canadians, have a family member who is a donor recipient, thankfully, here at home. But that limited availability that has people seeking, organs globally has become a legitimate issue for us. And I know that my colleague, Mr. Aboultaif, raised the domestic attempts at us trying to address the organ shortage that we have. And so I have a question for you along that line. Do you agree that the Government of Canada should consider the feasibility of a presumed consent system for organ donation, where individuals opt out instead of opting in, which some of the legislation, I think, is attempting to address? So I'll ask that first.
Mr. Ramsey, thank you for your question, and thank you for the support of the NDP. I know Ms. Laverdière and Ms. Hardcastle and others that have been engaged in discussions around this, as well as Mr. Rankin, your justice critic, and he gave an excellent speech on this issue in the House, and appreciate your presence and your commitment on this as well. In terms of some of the particulars around organ donation, I mean, it's a bit outside of the scope of the things I've been sort of most embedded in thinking about the testimony for today. I will say, in terms of a presumed consent model, there are many things we could do short of presumed consent that I think would substantially increase the availability of organs. We haven't yet, there's been a lot of discussion about it in this Parliament, but we haven't yet ventured down the road at all of what Sunstein and Thaler would call nudges in the direction of increased donation. Those nudges, the adjusting of the choice architecture, things like what my colleague Len Weber had proposed in a private member's bill, to have people on their tax forms indicate yes or no whether they're going to be an organ donor, to have people be automatically, in certain kinds of situations like filling out their taxes, presented with the choice, things like a national organ donation registry, greater public information. I think some people would have concerns about presumed consent as from a personal liberty standpoint, and I think there are a lot of things we can do before we have that discussion that might solve the problem as it is. So my inclination would be to take those steps first, and then we'll see what the impact of those steps are. Again, I mean, that's not a particularly well thought out response, because it's maybe outside of my outside of what my focus was today. But I think it's an interesting discussion. How do we increase organ donations? And obviously it fits into the broader question.
Yeah, I think it's important, because when Canadians are going abroad seeking organ transplants, seeking treatment that they can't receive here, as our colleague pointed out, they're maybe not given the best medical advice that they could be given, so it is endangering the lives of Canadians ultimately. And you spoke about that aftercare when they return home, and kind of all of those pieces. So I do think it fits into what you're attempting to sponsor here and have happen. The other question that I have is about other countries. Do other countries exercise the extra territorial jurisdiction over trafficking offenses that are related to the removal of human organs? And if so, what are some of the best practices that we see globally?
Yes, so other countries do have similar laws. It's kind of interesting how this whole effort was started by Canadians in terms of raising awareness of this. It was David Kilgore and David Matus that did the initial report, and I think it was David Kilgore who's mentioned to me it's a source of a little bit of embarrassment that you have these prominent Canadian experts that have done this work, and it's led to legislation being adopted in other countries, and yet Canada, the source country of these great experts who have done this work, has yet to pass legislation. So I know Israel, I believe Spain, Taiwan have passed legislation on this. I believe other jurisdictions have as well. I was just flipping for the list of countries in my notes, and maybe it'll come to me later on. But I know Israel, Taiwan have passed legislation. I believe Spain has as well. And I hope that by Canada doing it, we can kind of increase that global momentum towards getting more countries on board.
So can you speak then to what the impact of legislation has been in those countries?
Well, in general, where this has taken place, there's more awareness. It doesn't happen in the same way, the same levels. I know the story from Israel it was a doctor who kind of started this process there, because he had a patient who came to him and said they were going to a particular other country to receive a heart transplant, and it was scheduled for a specific day in the future, and noting his understanding of medicine, he said, wait, it's not really possible to know that a heart is going to be available. And it was through that it was unearthed that, well, probably somebody is having their life taken in order to have that transplant taken place. And so a big part of this battle is awareness, but also that disincentive. And so I think that's something we're seeing in those countries is an increased awareness and the disincentive that's there. But it's still a relatively small number of countries that have gone down this road. So it's still relatively new efforts. I think we'll see greater impacts over more countries and over more time.
Thank you.
Thank you very much. MP Vandenbeld, please.
I want to thank you very much, Mr. Genuis, for putting this incredibly important bill forward, and others before you, Mr. Wisniewski and others. And I'd just like to reassure you that we absolutely support. I have 100% support for what you are doing. It is a long time coming. I think that organ trafficking, illegal organ trafficking, is probably one of the vilest and most inhumane, worst forms of trafficking and of crimes that are happening internationally. And Canada should be leading the world in this regard. And we also share your urgency in terms of the need to make sure that we get legislation passed on this. So I would just like to ask you, in terms of the international community, we know in the Subcommittee on Human Rights, we heard from Uyghur testimony that said that they're being asked for DNA samples, which raises a very dark specter of why are they being asked for DNA samples. The UN Office on Drugs and Crime is saying that armed groups and terrorist groups are now using trafficking, including organ trafficking, as a means of funding their terrorist activities. No Canadian, I believe, would ever want to receive an organ from somebody where the person was either murdered or was extorted or coerced. I think this is something we all know is absolutely wrong. So could you tell the committee what are the trends internationally? Is this a problem that is increasing? Is this a problem that is getting worse? Is it spreading? What are the international trends?
Mm-hmm. Well, thank you very much for your question, for your support, Ms. Vandenbeld, and I found where I was looking at my notes, and it fits well within your question to say that countries that have passed similar legislation, I mentioned Israel, Spain, and Taiwan, but also Italy and Norway. So some other examples to look at in terms of similar legislation being enacted. And I think you outlined very well in your comments what the international trends are. What we see with China is sophisticated, well-organized abuse of human rights, and I think it's sort of a stereotype in our language that is false, where we tend to associate technological development, so-called civilization, with moral improvement. Those things do not go together in any sort of automatic sense at all, right? So when we look at China, we see the systematization of gross violation of human rights. I know the parliamentary secretary who's here and I have the honor of working together on the Canada-Tibet Parliamentary Friendship Group. So he's very aware of that in that context. I know as well as in other contexts in China. You mentioned the situation with Uyghurs, the collection of DNA samples. So there's a lot. At the same time as we see this going on, of course, these things aren't sort of publicly advertised in terms of exactly what they're doing, right? It does take the detailed work of people like David Matas and David Kilgore to unearth it. The link to terrorist financing, all of these things are emerging and growing problems, and they are part of what I referred to earlier in response to Mr. Yashnevsky's question. The changing impacts of injustice in an interconnected world, and we need to do all we can to make sure that we are not being in any way complicit in this. And I think your comments about terrorist financing underline, I think, another issue here, which is the security dimension of this, right? So I'm not the sort of person that thinks that everything has to be denominated in terms of security. Human rights is enough of a reason for me, right? But I think recognizing the security impacts as well of this, when you have this very strong potential revenue stream for extremist and dangerous organizations, that has an impact on our own security as well.
Okay. There are Canadians, particularly diaspora communities, who, if they need an organ, a lot of their family members are abroad, or there are dual citizens who may go to their home country where there might be things that are perfectly legal in order to get organs. Is there anything in this bill that would preclude somebody from being able to do something like that?
Great question. This bill does not in any way seek to restrict people from receiving organs from abroad if there is consent. The requirement is that they don't receive organs from abroad if there is not consent. Bill C-350, which was a bill I proposed, but it was wholly the same as a bill proposed by Irwin Cotler. It envisioned a system where somebody would bring a certificate with them attesting to that consent. I think there's some potential value in that, but there's also some complexity around assessing the validity of a certificate and countries where that just may not happen as a matter of course. So the way this legislation is set up is it would be incumbent on the prosecution to demonstrate based on a typical standard of proof that there was exploitation, that there wasn't proper consent. So does that mean that there are cases where someone might be involved in organ trafficking and it's difficult to prove, it's difficult to get a conviction? Well, yes, that's something that prosecutors deal with every day. But certainly the chances that somebody who simply innocently went abroad and received an organ for which there was consent, doing so in another jurisdiction which has the rule of law, or receiving from a family member, the risk that person would get caught up in a prosecution here is totally nil. If anything, the risk is greater the other way, that someone would do something nefarious and not get caught in a prosecution. But at least it's better to have this law than not have this law, even though we're not going to be able to successfully prosecute every case. Again, that's true of any law.
Okay, thank you very much. I think that brings us to the end of the questions for you, MP Genuis, and we really do appreciate you being here. I think you're hearing from all sides at the table that there is an acknowledgement and an importance of the importance of this particular bill, and you're right. It's about doing the hard work now to ensure a path forward that will see it successfully passed. So with that, I'm going to suspend. We have David Matas joining us at 9:45 by teleconference. So we will suspend, and then as soon as we've got that lined up, we will come back online. Okay, suspend. Zooming. Thank you, colleagues, for that. Just as we were getting set up for David Mattis. David, are you on the line?
Yes, I am.
Wonderful. Thank you for joining us this morning. David Mattis is a lawyer. He's the senior legal counsel for B'nai B'rith, and he is a subject expert and longtime advocate on the issue of human trafficking, organ trafficking. And we're very pleased to have him join us this morning from Winnipeg by phone. Mr. Mattis, if I can ask you please to provide testimony, and then we will certainly open things up to questions from members, which I know there's quite a few.
Sure. I've had some prior discussions about the bill with some of you, and there have been three different issues that have been raised. The issue of compulsory reporting, consideration for payment, and body parts other than organs. So let me say a bit about each of those issues. The issue about compulsory reporting is an issue where there was a constitutional question raised about because the bill now says reporting to a designated authority. And I looked at the definition of attorney general in the criminal code, because the bill says there has to be consent by the attorney general. And the phrase attorney general in the criminal code is defined to include or to mean the attorney general or solicitor general for the province in which proceedings are taken. And it's the attorney general for Canada only for Yukon, Nunavut, and the Northwest Territories. So that issue of constitutionality, as I see it, can be answered in one of four ways. One is just to leave the bill as it is and leave the issue of who the designated authority is to the governor and council, and the governor and council could, in theory, in consultation with the provinces, designate provincial authorities for each province where the attorney general has the power, or solicitor general has the power to consent to prosecution. So that would be one option. A second would be to change the bill to require the consent of the Attorney General of Canada as opposed to just the Attorney General, so that would allow for the designated authority to be federal. A third answer would be to change the consent requirement, as does exist in some parts of the criminal code, to be either the Attorney General of Canada or the Attorney General or Solicitor General of the province, which would maximize flexibility in terms of designation of the relevant authority. And the fourth possibility is to change the bill to require, instead of saying reporting by an authority designated by the Governor and Council, to require reporting to the Attorney General. And that would mean the Attorney General as defined in the Criminal Code, which would mean reporting to the Attorney General or Solicitor General in each province where proceedings might be taken. And I point out that's a common form of reporting, that a lot of because there's a lot of reporting legislation right now in Canada for child abuse, for gunshot wounds, and a lot of this reporting goes straight to the prosecutorial authorities. So those are the options that I saw for the first issue about reporting. In terms of consideration, the issue that has arisen is whether the bill, as it now stands, would penalize compensation to the donor for expenses incurred or income lost. There's, again, a couple of ways to deal with that. One is just to leave it to prosecutorial discretion and the consent of the Attorney General and not change the bill. A second is to have specific wording instead of saying consideration, say consideration for the purpose of exploitation, which is the language used right now in the Declaration of Istanbul in organ trafficking and transplant tourism. And it's a well-known concept in the criminal code, exploitation. It's mentioned 36 times now in the criminal code. In particular, it's part of the offense of trafficking of persons in the criminal code. The third issue is that I heard raised was the issue of body parts, whether the reference to organs is too narrow and whether the bill should also refer to tissue. And if the bill were amended to refer to tissue, the question would arise whether that's too broad and some forms of tissue need to be exempted. So again, there's more than one answer. One, again, is to do nothing because the fact that something more can be done that is worthwhile is not an argument for doing something which is in itself worthwhile, which is the bill right now. A second is to add tissue, but to rely on the concept of exploitation to avoid overbreadth. Presumably, consideration for those tissue which the bill would not intend to capture would not be consideration for the purpose of exploitation. The third option is to add tissue, but exempt specific tissue listed by regulation. But there would have to be, I would think, medical consultation to determine which tissue would fall within the regulation. So those are the various issues I heard discussed and the various options I present for your consideration. I realize there's a strategic consideration involved because if there's an amendment, then it has to go back to the Senate, and in theory, any one senator could delay passage of the bill through the Senate with amendment. But I feel in terms of strategic considerations, you're a better place to deal with them than I am, so I leave that to your wisdom. So those are my Mark.
Thank you very much, Mr. Mattis. We will now proceed to some questions for you, and we're going to begin with MP Genuis.
Thank you, Mr. Chair. Mr. Mattis, it's an honor to speak with you, even if it is over the phone, and thank you for your excellent work on this issue, as well as for some good discussion here about some of the legal details. These 3 points that we've discussed are important. I note that I think for each of the three, you've shown us that not amending the legislation is a strong option, and of course you're looking at it from a legal perspective. For us, the political perspective is very much doing something versus nothing. Maybe the reality we're up against. I just want to go through these 3 points again and probe them a little bit. So on the first point, the issue of reporting and the question of constitutionality, the legislation as it's currently drafted, if I understood you right, would fully allow governor and council to designate the appropriate provincial authorities, and that would get around any concerns about constitutionality, and provided that the government was making the appropriate designations, there wouldn't be any question about treading on the division of powers, because of the ability to designate that is open within the legislation. Did I understand you right on that point?
Yes, I mean, in terms of constitutionality, because right now the criminal code says Attorney General, but includes in the concept of Attorney General, the Attorneys General of the provinces. And so I don't see any real difference between that and the Governor and Council designating provincial authorities to deal with the issue. It strikes me as the same type of constitutional division of powers.
So it seems then that although there are other options for dealing with that issue, that the current legislation provides a strong and effective framework for responding to that. Now, on the issue of consideration, it seems like a pretty out there speculation that somebody would attempt a prosecution on the basis of someone's expenses getting covered. That seems to me, covering someone's expenses so that they can provide a voluntary service seems very, very different from doing something for consideration. And in any event, there's prosecutorial discretion, but there's also the requirement of sign off from the Attorney General. Do you think that is sufficient to ensure that sort of a minimally reasonable reading of this, as well as those elements of discretion? Do you think that is sufficient to respond to potential concerns around a wild misinterpretation of the concept of consideration?
In principle, it could be. I mean, I'm familiar with the concept of consent of the Attorney General because it exists in a lot of other provisions of the Code. And some of the, in particular, I've been dealing with the consent of the Attorney General through the concept of prosecution for incitement to hatred. And in British Columbia, for instance, the Attorney General has set out criteria for exercise of consent, and so there's a kind of intermediate step between complete discretion in all cases and something specific in the bill, and that is guidelines or criteria the attorneys general together or individual attorney generals could lay out for the granting of their consent.
One other quick issue on that is the prospect of changing it to for the purpose of exploitation. I guess one possible worry I would have for that is that does that for the purpose of exploitation refer to the intention of the recipient? Because somebody might be receiving an organ without any sort of specific intent to exploit, in that they might be grossly negligent and their intention is to get an organ for themselves, and they're being negligent and so forth, but they're not. They're exploiting in fact, but they're not seeking exploitation. Do you understand what I mean?
Yes. Well, in general, the criminal law includes both intent and recklessness, and so if somebody is willfully blind, that might well be covered for the purpose of exploitation. But if you can't establish a requisite criminal intent, then you couldn't get a conviction.
Thank you. And then I think it is just worth noting that the original version of the bill referred to tissues, but that was removed by the Senate. So any change we would make that would reintroduce the concept of tissues or body parts would raise questions of further back and forth and create greater challenges. But I'm also curious to know if the term organ is defined anywhere in the criminal code, because this bill doesn't include a definition for organ. So in a way, I think it's open enough for organ to include body parts, but not the kind of tissues that the Senate wanted to exclude, things like embryonic tissues that raise a lot of other kinds of considerations.
I'm not familiar with the definition of organs in the criminal code, but the tissue is. I don't think we should stray too far from ordinary English language understanding or medical understanding of the terms, and tissue is a distinct concept from organs. It is possible, I suppose, to define organs to cover more than what's ordinarily understood as organs, but that would raise the issue of a further amendment. And so I think if we have organs and not tissue, we're stuck with organs and not tissue. I mean, I see that as not necessarily a problem because the bill, I mean, you can always think no matter what legislation you have or something that you can add that might improve it, but there's nothing wrong with the bill that is as it stands simply because tissue's not there.
Thank you very much. Parliamentary Secretary Virani.
Thank you, Mr. Matus. It's always a pleasure to hear from you. Thank you for your long work on this, the objectives that are being sought by this bill. I will be candid with you and say that there has been some concern expressed, and I share some of the concern with respect to the financial transaction component. So that's what I'm going to ask you about. And it dovetails from what Mr. Jennis just said about how there was a differentiation made on organ versus tissue in the Senate, and I think they were very live to the issue about reproduction issues and people going abroad to obtain sperm and ova, for example. But we're also quite live to the issue of people who, I think the easy case, Mr. Matus, is the one where there's a prisoner, clearly no consent, their organs are harvested against their will. that's targeted by this bill. That's something that obviously all parliamentarians want to address. The tougher case is a situation where people have are in, because of the organ shortages in this country, are forced in desperate circumstances to go abroad to seek organs and end up transferring money in the process of procuring that organ, even if they believe that they've obtained consent. So what I want to ask you about is the aspect of consideration, and specifically what I want to ask you is whether informed consent is enough simpliciter to address the issue. So, and I put it to you this way, Mr. Matus. So if someone is obtaining an organ through unethical practices like inducing the consent of a person by deceiving them about the nature, risks, or consequences of the procedure, would that constitute a lack of informed consent on its own?
Obviously, when it comes to whether or not an offense is committed in hypothetical examples, that's really something that the prosecutorial authorities have to decide based on the facts of the cases, because no case in reality quite conforms to a hypothetical example we can imagine. I can see that what's behind the notion of informed consent, to a certain extent, is trying to, in another way, get at the issue of exploitation. And so it's another way of saying that the bill itself may be sufficient already in its terms, but I do think that if the committee wants to be more explicit, it could add the concept of exploitation. I mean, obviously the intent there is that you not take advantage of the source in any way, whether it's through payment or pressure or incentives. The idea is that it has to be truly voluntary, and of course the classic case is somebody in detention, but there are lots of non-detention cases where we can see or can think of examples where the situation is not truly consensual. But I think that all Parliament can do is set out principles and set out general language. And but when it comes to specific cases, I think we really have to leave it to the prosecution to try to capture the intent of the legislation.
Okay, but just further to that, Mr. Matus, because right now, I mean, the clause as it's structured, and this came up when MP Janice was testifying as well, but the clause as it's currently structured creates an offense with respect to the financial flow of consideration. So it's not restricted to only consent. So I put that out there. But secondarily, I think it's also important as parliamentarians that we target it as much as possible to what you described as taking advantage, or exploitation was the language that you suggested. Because right now it actually criminalizes both the provider and the purchaser, so the vendor and the purchaser. So that's a concern that I have as well. And because I think what we're trying to address, what I would think we were trying to address, is the purchasers and also perhaps the sort of the middleman, for want of a better phrase, or the broker who connects a potential purchaser with a potential vendor. The vendor, who sometimes people describe as the destitute farmer in some developing country, for want of a better example, that's probably the last person we want to criminalize. And I think on my reading of that clause, sub 3 in this bill, that person would be criminalized according to the way sub 3 is reads right now. So could you comment on that?
Well, I guess my general comment is that one can look at the bill and think of ways in which the bill could be amended so that the intent could be more specific, and that problems we can imagine could be explicitly addressed. If it was just a matter of the House of Commons making amendments and the bill being passed, I don't think it would be much of an issue. The problem is that any amendment, even the slightest one, means that the bill goes back to the Senate, and the Senate, the way it functions, as I understand it, any one senator can delay the passage of the bill for any reason, and as a result of which the bill might be potentially delayed beyond the next election, and so it becomes a problem potentially with any amendment of getting into that cycle. And I have no, as I say, I mean that's kind of more of a strategic issue than a legal issue, and I really leave it to the committee to decide what the risk is of that happening. But I would say if there's no risk of that happening and it's simply a matter of improving on the wording of the bill, then I would say sure, by all means.
And your opening statement was that a potential improvement on the wording would be consideration for the purpose of exploitation, and you said that exploitation is used 36 different places elsewhere in the criminal code. Did I get that right?
Yes, that's right. And in particular, I mean, of course, some of the uses are not that relevant to the use here. But one that is relevant to the use here is the trafficking in persons provision. And the trafficking in persons provision has the concept of exploitation built into it, and sometimes indeed that trafficking in persons is so close to trafficking in organs that sometimes it's included within the concept. Trafficking in organs is included within the concept of trafficking in persons. So I think that would be an easy phrase to adopt or an example to follow.
And can I put to you just very quickly, just the notion of removing the financial transaction component entirely so that it's just an informed consent-based regime. Can you tell me about whether that addresses the objectives of the bill?
10:30.
Well, I think that it would have to expand the concept of informed consent, but as long as one interprets informed consent as including the avoiding exploitation, that would be another way of doing it, I would say, yes.
Thank you.
Thank you. Thank you very much. We will move to MP Ramsey, please.
Thank you, and thank you, Mr. Mattis, for being here via teleconference. I have a couple of questions for you. I want to ask about whether or not the offenses that are created in S240 are already covered by the Criminal Code sections 27901 and 27904 subsection 3, and if you can speak to why or why not.
I mean, if you look at those sections and you look at the bill, there's a lot more detail here in the bill, and whether it's covered or not becomes an issue of speculation or uncertainty. The advantage of the bill, well, first of all, it does have some concepts that are not in the current law about immigration, about reporting. But even if you look at the offenses that are in the code, they're not as specific. Also, this bill addresses extraterritoriality, which the current provisions in the bill do. The current provisions in the code do not. They're just local offenses. As far as I'm concerned, if I had a choice between just making the current provisions in the code extraterritorial with an add-on for reporting and immigration, or the present bill, I would prefer the present bill because it's just a lot more specific, and we don't get into the issue of is it covered, is it not covered. We know for sure it's covered.
Okay, thank you. The word consent is used in various sections of the criminal code without being defined. I wonder if you can speak to the importance of the Senate adding the definition of informed consent in S240.
Well, I testified before the Senate, and I sat through other testimony, and this was not a suggestion I made, but I recall when I was there, it was a suggestion that other witnesses had made, and it's got a history a medical history that, because of course, in the medical profession, you need consent to engage in a lot of medical procedures, and that's what they're looking for is an informed consent. And so, my understanding is it's drawn from a kind of medical practice of seeking consent. So you can't just get somebody to say yes. You have to get somebody to know what's going on before they say yes. And I think that was the point behind it.
Thank you. And how does the current state of Canadian law on trafficking in human organs compare to international standards?
Well, international standards are developing. Right now, there's a treaty that's open for signature and has come into force through the Council of Europe on organ trafficking that actually is quite close to this bill. It might take a more careful look, but my initial reaction is that if this bill were passed, Canada would be in a position to sign that treaty. Canada is an observer state to the Council of Europe and can sign that treaty if it wants to, and I think they should. I think this bill would be helpful in putting them in a position to do so.
Thank you. The last question that I want to ask you is about like-minded countries who have implemented similar legislation. MP Janice mentioned earlier Israel, Spain, Taiwan. I want to ask you what the impact has been of the legislation in those countries.
Well, in Taiwan and Israel, it's been dramatic. The legislation in Spain, I don't know that Spain had much of a problem of transplant tourism before, but certainly in Taiwan and Israel, there was a big transplant tourism before, and the problem in both countries was transplant tourism into China, and after the Israeli legislation was passed, it went from being very common to disappearing altogether, or almost altogether. Taiwan had a similar impact. Taiwan tried to deal with the problem of transplant tourism into China initially through ethical standards of the medical profession through their health ministry, but that wasn't working very effectively. So they felt that they had to move to legislation to deal with the problem. And and now that they do have legislation, it has had a big impact and a sharp downturn on transplant tourism into China. So the legislation in those two countries has practically been very impactful.
Thank you very much.
Thank you, MP Ramsey. Given that the bells are going and there's a vote at 10:30, I would just like to seek unanimous consent to continue sitting up until maybe 10 minutes before the bells, given that it's close proximity. Seeking unanimous consent? Thank you. Right. We will continue, and we will now go to MP Jasneski, please.
Thank you, Chair, and thank you, Mr. Mattis, for joining us this morning. We seem to be talking a lot about two issues here, the issue of consent and the issue of a financial transaction. And by the nature of this industry, and prior to your book, the expose, it in places it had become an industry. There's two parts. There's the taking of organs from vulnerable individuals, and then there's the financial transaction. It is an industry in the sense that huge amounts of money get transferred. And what makes it particularly horrific is the nature of the industry, that it's actually state parties, states whose role is to protect the citizenry, who are the guardians of citizens' well-being, are involved in the trafficking, or when it's criminal gang traffickers, as we saw with Dr. Kumar from Brampton, who had these clinics in India. Doctors and nurses are part of the criminal gangs. They have a Hippocratic oath. So the very individuals and institutions that we should trust with guardianship are abusing their position, and it's for the benefit of the financial rewards. I referenced it earlier, and I'd like to reference it again. I first became aware of this in the summer of 2007, and it was a case in Ukraine where the director of an orphanage, the guardian, was giving consent for the children who were at the age of 17 and just before their 18th birthday and they'd be put out of the orphanages, was giving consent on behalf of those children to be sold, and the children would then disappear. So I think it's very important, and thank you for the wording from the Istanbul Declaration, the wording for the purpose of exploitation, because there's this whole idea of guardianship and consent that I think that wording provides additional clarity, so we don't inadvertently end up dealing with an issue that perhaps there are tax credits that certain states in the U.S. offer, and it allows us to specifically deal with the financial transaction part, the way it's specified in the legislation, because that is the second part of this trafficking. There's the taking of the organs and the financial transaction. Thank you for that wording. I just wanted to put that on the record, and I'd like to pass the rest of my time over to Mr. Sani.
Good morning, Mr. Mattis. Thank you very much for coming. I know we've been speaking a lot about financial consideration, but I want to give you a specific example. As you know, there's millions of Canadians who live in Canada who have extended families abroad, myself included, especially in Southeast Asia. And if you have very small family members here, or a limited amount of family members here, and you return back to your origin country, and you have an extended family there, whether it be cousins, uncles, second cousins, and you find that you have a relative who can donate an organ, and obviously, as you know, in certain countries, the healthcare system is not robust publicly, so you have to go to the private system, and you decide to cover the expenses for that relative. Would this act, as it's currently written, criminalize that? And if it does, is there some way to protect a legitimate sort of procedure from one family member to another?
Well, I would say that, again, we're dealing with a situation where it's a hypothetical situation with hypothetical facts, and it may well be a situation where if it's put to an attorney general to ask for consent, or it's put to a prosecutor for prosecution, prosecutorial discretion would come into play, or the withholding a consent of the attorney general might come into play. One might even have guidelines about how consent would be issued, which could deal with that particular situation. I don't think what we're doing here is when we pass any criminal law is saying that every hypothetical example that might fit within the wording is going to lead to a conviction or even a prosecution. In that type of situation that you describe, my own view is that's not the intent of the legislation. It's not intending to get at that sort of a situation. The issue for the committee is whether the current wording is sufficient to alleviate that concern, or whether some more specific wording is needed to make sure that that problem doesn't arise.
Thank you. Thank you very much, Mr. Mattis. Given that we now have about 7 minutes until we had the time we had set to adjourn, I'm going to thank you for being with us. We actually have some committee business to go over. So with that, I will bid you farewell, Mr. Mattis. And again, I thank you for your advocacy and your leadership for decades on this file. Thank you, sir.
And thank you.
Make a statement.
So I recognize MP Ellslev.
Well, thank you very much, Mr. Chair. A few weeks ago, the International Republican Institute and the National Democratic Institute testified before this committee about their promotion of democracy. I think it's important to recognize two elections that they observed by these two institutes and Canada's appreciation of them. A joint IRI-NDI observation mission observed Saturday's National Assembly elections in Nigeria, an emerging African democracy. NDI president said the following: "The resilience and strong dedication to democracy of the Nigerian people was inspiring to observe. Despite the country's many challenges, the international community should continue to invest in Nigeria's democratic promise." I think I speak for all parliamentarians here that Canada is proud of Nigeria's march toward greater democracy. And then, in another election, this past Sunday, Moldova held parliamentary elections which IRI observed, including a Canadian long-term observer from Saskatchewan as part of their team. The results have led to a hung parliament, and the IRI mission has congratulated the Central Election Commission of Moldova for running a successful election. Again, I believe I speak for all Canadian parliamentarians that we look forward to Moldova's democratic future. This was a good 2 days for democracy. Thank you, Mr. Chair.
Thank you, MP Ellslev. We will now go in camera.